Justice regarding the minister's actions being contrary to norm and unusual were made in respect of the appropriateness of the particular recommendation, as the Chief Justice would be undoubtedly be aware that the minister is constitutionally authorized and obliged to recommend an acting appointment with the concurrence of the Chief Justice. The Constitutional Court also dealt with the provision allowing for the appointment of an acting Constitutional Court judge. At the time of the certification proceedings, the provision required the appointment to be made by the President on the recommendation of the Minister, acting with the concurrence of the Chief Justice. The Constitutional Court dealt with the objection as follows, and I quote, "Appointment of an acting judge to the Constitutional Court is in a special category. The Minister of Justice and Chief Justice and the President of the Supreme Court of Appeal are members of the JSC, and the requirement that there be agreement between them as to the person to be appointed meets any reasonable concern that the power of appointing an acting constitutional judge might be abused," unquote. The Constitution was subsequently amended. The amendment, Section 175(1), requires the President to make the appointment on the recommendation of the Minister and the Chief Justice only. The amended provision therefore only requires the concurrence of one senior judge and not two, as was previously required. It should be noted that when Chief Justice Zondo did not give his concurrence to the Minister did not proceed to recommend to the President that Judge President Mlambo be appointed as acting judge of the Constitutional Court for the period of 1 August 2021 to the 30th of September 2021. The Minister therefore did not contravene Section 175, subsection 1 of the Constitution. Section 96, subsection 1 and subsection 2b of the Constitution require a member of Cabinet, in this instance the Minister, to act in accordance with the Executive Ethics Code and to not act in any way that is inconsistent with his office or expose himself to any situation involving the risk of a conflict between his official responsibilities and private interest, respectively. Whereas in terms of Clause 2.1 of the Executive Ethics Code, the Minister is required to perform his duty, including his constitutional obligations, diligently and honestly, and in this instance, his duty to recommend judges to the President for appointment of acting judges in the Constitutional Court. The complainant's contention is that the conduct of the Minister in suggesting Judge President Mlambo to Chief Justice Zondo to be recommended to the President for acting appointment in the Constitutional Court for the period of 1 August 2021 to 30 September 2021 was to give him an unfair advantage to be appointed Chief Justice of the Constitutional Court, therefore breached Sections 96, subsection 1 and subsection 2b of the Constitution, read with Clause 2.1 of the Executive Ethics Code. The investigation revealed that it is not the first time Judge President Mlambo was identified for an acting appointment in the Constitutional Court. The evidence further reveals that he was appointed as acting judge of the Con Court for the period of 16 January 2022 to 30 March 2022. On both occasions, he was suggested by the former Chief Justice and he declined. He was later suggested by Chief Justice Zondo. He accepted and he was appointed as acting justice in the Constitutional Court. At all occasions, it was not the Minister who suggested him to be appointed as acting justice in the Constitutional Court. The Minister said recommended by the Minister, nor appointed by the President as acting justice for the Constitutional Court. However, Judge President Mlambo was, on recommendation of the Chief Justice, appointed by the President as acting justice in the Constitutional Court for the period of 16 January 2022 to the 31st of March 2022 on recommendation by the Minister, dated 23 November 2021. Section 175(1) of the Constitution requires the Minister, with the concurrence of the Chief Justice, to recommend judges to the President for appointment as acting judges in the Constitutional Court. The conduct of the minister in particular, that is, to suggest the name of Judge President Mlambo for acting appointment to Chief Justice Zondo, was not inconsistent with Section 175, subsection 1 of the Constitution. Therefore, the conduct of the minister in this regard was not in breach of Section 96, subsection 1, in subsection 2b of the Constitution and Clause 2.1 of the Executive Ethics Code. Accordingly, it was found that the allegations that the Minister of Justice and Correctional Services violated Section 175(1) of the Constitution when he suggested Judge President Mlambo to Chief Justice Zondo for concurrence and recommending him to the President for acting appointment in the Constitutional Court, and therefore breached Sections 96 subsection 1 and subsection 2b of the Constitution and Clause 2.1b and c of the Executive Ethics Code, is not substantiated. On the second issue, whether the President violated Sections 171(1) of the Constitution when he appointed Judge President Mlambo as acting judge of the Constitutional Court, and if so, whether such conduct was in breach of Section 96 subsection 1 and subsection 2b of the Constitution and Clause 2.1b and c of the Executive Ethics Code, the following conclusions are reached. Section 96(1) and 2b of the Constitution requires a member of Cabinet, and in this instance the President, to act in accordance with the Executive Ethics Code and not to act in any way that is inconsistent with his office or expose himself to any situation involving the risk of a conflict between his official duties and private interests. Furthermore, in terms of Clause 2.1 of the Executive Ethics Code, the President was required to perform his duty, including his constitutional obligations, in this instance the appointment of acting judges in the Constitutional Court, diligently and honestly. Section 175(1) of the Constitution enjoins the President in appointing acting judges in the Constitutional Court to do so on recommendation of the Minister acting with the concurrence of the Chief Justice. The President appointed Judge President Mlambo to act in the Constitutional Court for the period 16 January 2022 to 31 March 2022. This was after Judge President Mlambo was recommended to the President by the Minister on the 23rd of November 2021, acting in concurrence with Chief Justice Zondo. When appointing Judge President Mlambo, who was recommended by the Minister acting with the concurrence of Chief Justice Zondo, the President fulfilled his constitutional duty in terms of Section 175(1) of the Constitution, as required by Section 96(1) and 2b of the Constitution, read with Clause 2.1 of the Executive Ethics Code, which requires the President to perform his constitutional obligations diligently, honestly, and in the best interest of good governance. The President appointed Judge President Mlambo as acting justice of the Constitutional Court for the period 16 January 2022 to 30 March 2022 on receipt of the recommendation from the Minister dated the 23rd of November 2021, indicated that he had the support of the Chief Justice in terms of Section 175(1) of the Constitution. We thus could not find evidence that the President had violated Section 175(1) of the Constitution at the time he appointed Judge President Mlambo as acting justice in the Court. Therefore, no evidence could be found to support the allegation that the conduct of the President in this regard was in breach of Section 96(1) and 2b of the Constitution and Clause 2.1 of the Executive Ethics Code. Accordingly, the allegation that the President violated Section 175(1) of the Constitution when he appointed Judge President Mlambo was as acting judge of the Constitutional Court and therefore breached Section 96(1) and 2b of the Constitution and Clause 2.1b(c) of the Executive Ethics Code, is not substantiated. It should be noted that upon being served with the notices in terms of Rule 41(1) of the Public Protector Rules, which basically gives the complainant an opportunity to make representations upon a finding that the allegations are not substantiated, Ms. Pasha indicated that she withdraws her complaint, whereas Mr. Shivambo MP did not respond to the notice. So in line with the Public Protector Act, the matter is closed. I move over to report number 12 of 2023-2024. During the course of June 2022, complaints were lodged with the Public Protector in respect of allegations of violation of the Executive Ethics Code against the President of the Republic of South Africa, Mr. Matamela Cyril Ramaphosa, as well as allegations of improper conduct against members of the South African Police Service in terms of the Public Protector Act. The complaints were lodged by Mr. Vuyolwethu Zungula and Mr. John Steenhuisen, who are members of the National Assembly, in terms of the Executive Members Ethics Act, as well as by Mr. Elias Miller and Mr. Simpiwe Ndlovu, who are ordinary members of the public, in terms of the Public Protector Act. We received 2 written complaints dated the 2nd and the 3rd of June 2022 from Mr. Zungula in connection with allegations that the President had violated the Executive Ethics Code of 2000 published by the proclamation in Government Gazette number 21399, notice number 41, regulation 6853, known as the Executive Ethics Code, in relation to the housebreaking with the intent to steal and theft of cash in foreign currency that took place on or about the 9th of February 2020 at Phala Phala Farm, Waterberg in the Limpopo province. Further to the complaint from Mr. Zungula, we subsequently received 3 more similar complaints in June 2022 from other complainants, namely Mr. Steenhuisen, Mr. Ndlovu, and Mr. Miller. All the complaints were based on the affidavit of Mr. Arthur Fraser, the former Director General of the State Security Agency, which at the time was not in the possession of the Public Protector, but was in the public domain and circulating around various media platforms, indicating, amongst other things, that Mr. Fraser had laid criminal charges against the President at the Rosebank Police Station in Gauteng. The complaints were then consolidated into one file to avoid a duplication of investigations, as the facts arose from the same incident and are mutatis mutandis. The complainants were all notified accordingly of this development. An objection was raised by Mr. Zungula to this method of dealing with the matter. The objection was premised on the notion that the consolidation of the complaints would have the effect of prolonging the investigation. In response thereto, Mr. Zungula was advised that the Public Protector Act conferred on the Public Protector the sole discretion to determine the format and procedure to be followed in conducting an investigation, with due regard to the circumstances of each case, and that this position had been reiterated by the Supreme Court of Appeal. This aspect is dealt with more elaborately in the report. At this stage, it suffices to say that the investigation process was inevitably going to be informed by the provisions of Section 6 and Section 7 of the Public Protector Act, which on their own carry no inherent risk of delays into the course which the investigation pattern may follow, regardless of whether the matter is pursued under EMEA or the Public Protector Act. Furthermore, the Public Protector South Africa is on record on its presentation to Cabinet on the 24th of May 2017 that, amongst others, on the challenges faced in complying with the statutory requirement to finalize and report on a EMEA investigation within a period of 30 days due to factors such as the internal capacity constraints and the scope of the investigations, such as the one of this nature. This challenge is, however, mitigated by Section 3, subsection 3 of EMEA, which permits the public protector to report to the president or the premier in circumstances where an investigation would not be completed in 30 days. The substance of the objection to the approach to the public protector South Africa's reporting obligations in terms of the EMEA is informed by an interpretation of the relevant legislative framework, which is within the exclusive prerogative of the acting public protector in this instance. Mr. Zungula's insistence that an interim report be released on the merits of the complaint prior to the completion of the investigation was therefore deemed as contrary to the legal standards that ought to be complied with, as have been applied by all public protectors since the promulgation of EMEA. The investigation was conducted in terms of Section 182(1) of the Constitution, read with Section 3 of the EMEA, and Section 6, subsection 4 of the Public Protector Act. It included an analysis of all relevant documentation, the application of relevant law, case law, and related prescripts. All the relevant information relied upon to reach the conclusions detailed in the report are specified in the report. The investigation looked into the conduct of number of persons, namely the President of the Republic of South Africa, Mr. Ramaphosa, the National Commissioner of SAPS then, General Fani Sihlane Masemula, the current commissioner rather, and the former Commissioner of SAPS, General Kehla Stole, the former Special Advisor to the President, Mr. Benjani Chauke, the head of the Presidential Protection Services, Major General Wali Rweda, and an official of the Presidential Protection Services, Sergeant Hlulani Rikota. Other persons to whom the notice were delivered on the 10th of March 2023, as well as the final report being issued today, have been delivered to are the Speaker of the National Assembly, Mrs. Nosiviwe Maphisa-Nqakula, the Minister of the South African Police Service, Mr. Bheki Cele, as well as all the complainants in the matter. With the complaint having been lodged partly by members of the National Assembly under the EMEA, there is no discretion to consider whether or not to investigate a matter, as the EMEA provisions in this regard are peremptory. The alleged improper conduct by the President involving a potential violation of the Executive Ethics Code was therefore investigated under Section 3, subsection 1 of the EMEA. Although Mr. Ndlovu and Mr. Miller's complaints relate to the same allegations that on the 9th of February 2020, there was a theft of millions of US dollars stored within the President's private residence at Phala Phala farm, their complaints are not covered under Section 4, subsection 1 of the EMEA. Section 4, subsection 3 of the EMEA indicates that nothing in this section may prevent the public protector from investigating any complaint by a member of the public in accordance with the Public Protector Act. Mrs. Ndlovu and Miller's complaints were accordingly dealt with in terms of the Public Protector Act. The factual inquiry principally focused on whether or not the President violated the Executive Ethics Code as a result of the alleged housebreaking with the intent to steal and theft of cash in foreign currency that took place on or about the 9th of February 2020 at Phala Phala farm, and or acting in a way that is inconsistent with his office in a manner that he dealt with the alleged crime. Another part of the factual inquiry principally focused on whether the members of the South African Police Service failed to comply with and uphold their statutory and constitutional duties in relation to the events that followed the housebreaking with the intent to steal and theft of cash in foreign currency, which took place at Phala Phala farm. The inquiry regarding what should have happened focused on the law and rules that relate to the standard that should have been met by the President to comply with the Executive Ethics Code and by the members of the SAPS to act in accordance with the standard expected in the proper performance of their constitutional and statutory duties. The inquiry regarding the remedy or remedial action seeks to explore options for redressing the consequences of the improper conduct or the maladministration. This approach included a variety of methods, such as an exchange of documentation between the institution, the President, the Speaker of the National Assembly, Mr. Fraser, various state institutions, managers of Phala Phala Farm, as well as other individual witnesses who are in possession of information which has a bearing on the investigation of this matter. It is acknowledged that when the details of the Phala Phala Farm incident came to light in 2022, multiple oversight mechanisms sprang into action, sometimes working collaboratively, at times in parallel, which resulted in several institutions and oversight bodies simultaneously being seized with the investigation of the same matter in accordance with their own functions and mandates. And this includes the South African Revenue Services, the South African Reserve Bank, the Directorate of Priority Crimes Investigation, the Financial Intelligence Center, the Independent Police Investigative Directorate, the independent panel appointed by the South African Parliament in terms of Section 89 of the Constitution in October 2022. The laws and policies that inform the investigations in the above institutions are in line with the prescribed mandates. Various case law, which is cited in the report, was also considered. The analysis of the complaint led to the identification of 3 issues for the investigation. Firstly, whether the President of the Republic of South Africa, Mr. M.C. Ramaphosa, acted in a manner that is inconsistent with his office in dealing with the alleged housebreaking with the intent to steal and theft of cash in foreign currency that took place on or about the 9th of February 2020 at Phala Phala Farm, Waterberg in the Limpopo province, and thus abused state resources, exposed himself to any situation involving a risk of a conflict between his constitutional duties and obligations and his private interests arising from or affected by his alleged paid work in violation with Clause 2.1 B and D and Clause 2.3 D, F, G of the Executive Ethics Code. Whether the President failed to report the alleged crime that took place at Phala Phala Farm on or about the 9th of February 2020 and abused his power in utilizing state resources by causing the Presidential Protection Services, known as the PPS, to be deployed to Phala Phala Farm and to investigate a housebreaking with the intent to steal and theft of cash of foreign currency at Phala Phala Farm, thus violating Clause 2.3D and F of the Executive Ethics Code, and whether such conduct constitutes improper conduct as contemplated in Section 182, subsection 1 of the Constitution, and abuse of power as contemplated in Section 6, subsection 4A and Roman numeral 2 of the Public Protector Act, and whether the members of the South African Police Service, which shall hereafter be referred to as SAPS, attached to the PPS, acted improperly by investigating the alleged housebreaking with the intent to steal and theft of cash in foreign currency, which took place on or about the 9th of February 2020 at Phala Phala Farm, Waterberg in the Limpopo province, and if so, whether such conduct constitutes improper conduct as contemplated in Section 182(1)A of the Constitution, and maladministration as contemplated in Section 6, subsection 4A, Roman numeral 1 of the Public Protector Act. On the first issue, it's whether the President of the Republic of South Africa acted in a manner that is inconsistent with his office in dealing with the alleged housebreaking with the intent to steal and theft of cash of foreign currency that took place on or about the 9th of February 2020 at Phala Phala Farm, Waterberg in the Limpopo province, and thus exposed himself to any situation involving a risk of a conflict between his constitutional duties and obligations and his private interests arising from or affected by his alleged paid work in violation of Clause 2.1 B and D and Clause 2.3 D, F and G of the Executive Ethics Code. Upon analysis, it was considered that the President's response is a denial of allegations that he undertook paid work outside his cabinet duties. The President denied any breach of the Code of Ethics and Section 96, subsection 2A and B of the Constitution. He stated that he does not work for Tabanyoni or Phala Phala farm and was not paid for anything. The concept of paid work and or remunerative work was not defined in the Constitution, EMIA, or the Code of Ethics. In order to arrive at the decision whether the President breached the Constitution and the Code of Ethics, it is pertinent to interpret and determine the meaning of the concept. I quote, undertakes any other paid work, I unquote, and or receive remuneration for any work or service other than for the performance of their functions as members of the executive ethics. Own emphasis. The modern approach to interpretation is neatly summarized as follows by the Constitution. I quote, the interpretation of the Act must be guided by the following principles. A, words in a statute must be given their ordinary grammatical meaning, unless to do so would result in an absurdity. B, this general principle is subject to the three interrelated riders. A statute must be interpreted purposively. The relevant provision must be properly contextualized, and the statute must be construed consistently with the Constitution, meaning in such a way as to preserve its constitutional validity. I unquote. In the matter of the Public Protector and others versus the President of the Republic of South Africa and others, the court stated that, I quote, the Constitution, the Members Act, and the Code exist for the purpose of enhancing and enabling the attainment of justice, giving substance to our founding values, and ensuring compliance with high ethical standards and constitutional obligations. They are not to be interpreted in a way that impedes the realization of these critical objectives. Courts should not therefore inadvertently enable schemes designed to or that could unintentionally frustrate the fulfillment of ethical imperatives and constitutional obligations by allowing legal sophistry or technicalities to obscure commonsensical realities. I unquote. Section 1 of the Basic Conditions of Employment Act states that, I quote, remuneration, I unquote, means any payment in money or in kind, or both in money and in kind, made or owing to any person in return for that person working for any other person, including the state, and remunerate has a corresponding meaning. In terms of Section 30, subsection 6A of the Companies Act 71 of 2008 as amended, I quote, remuneration includes fees paid to directors of service for services rendered by them to or on behalf of the company, including any amount paid to a person in respect of the person's acceptance of the office of director. I unquote. Section 1 of the Occupational Health and Safety Act provides that employer means, subject to the provisions of subsection 2, any person who employs or provides work for any person and remunerates that person, or expressly or tacitly undertakes to remunerate him. The OHSA also defines remuneration as any payment in money or in kind, or both in money and in kind, made or owing to any person in pursuance of such person's employment. The OHSA further defines employment or employed as meaning employment and employed as an employee. The OHSA further defines work to mean work of an employee or as a self-employed person, and for such purpose an employee is deemed to be at work during the time that he is in the course of his employment, and a self-employed person is deemed to be at work during such time as he devotes to work as a self-employed person. The guide on managing other remunerative work in the public service states that to have an interest in a business is not work per se. There has to be evidence of a physical or mental effort contributing to the operations of the business over a period of time. Over a period of time means the event continues for a period of time without stopping. According to the affidavit of General Rueda, the President declined the permanent deployment of the PPS personnel and technology at the Phala Phala farm on the basis that he is not always there. Having assessed the definition or meaning of paid work or remunerative work, it is prudent to state that applicable sources in the main refer to employees in the employ of the state rather than specifically to the members of the executive. However, for the purposes of this investigation and determining the ordinary meaning of the relevant statutory provisions, these guidelines serve as the only source of interpretation of the concept of paid work or remunerative work. In the case at hand, the meaning of the words paid work or remunerative work appear to be plain, as well as in harmony with the syntax in which it occurs. The wording should therefore be interpreted in line with its ordinary grammatical meaning. Objectively viewed, these words mean that the member of cabinet must not, regardless of the form of work or agreement in place, be paid or receive remuneration in respect of any work other than work related to his or her duties as a member of cabinet. The only prohibition that rises from the scheme of Section 96, subsection 2A of the Constitution and from Clause 2.3g of the Code of Ethics is narrow and focused, and that is to say a member of cabinet may not do other work for which he or she gets paid or receives remuneration. Within this context, it is imperative that consideration be given to the purpose of the prohibition of undertaking other paid work. This is one of the most important considerations which ultimately informs whether or not there has been a violation of the provisions of the Code. That purpose can only be to ensure that members of the executive give their undivided attention to their jobs as a part of the executive and to prevent them from becoming distracted by other work that they could earn remunerative work from. In other words, their prohibition is on earning other active income, in the sense that it is income earned in exchange for work or services that would distract the member concerned from fulfilling their functions in government. At the same time, when read in context, the EMIA and the Code recognize realistically that members of the executive will hold financial interests. These other interests will in most instances also produce income for the members concerned, such as rent received from immovable property owned by the member and leased out, or dividends received as a stakeholder in a listed or private company. Members are required to disclose these interests in terms of Section 2, subsection C of the Act and paragraph 5 of the Code. In the Code, there is therefore nothing per se problematic with members of the executive holding financial interests which may provide them with another source of passive income which they receive without having to undertake work or provide services. What is prohibited is the active involvement of members in the enterprises which produce the income, because that would divide their attention from their official duties. Very often, determining this issue will be a matter of degree, and the dividing line between passive or permitted involvement and active prohibited involvement will be difficult to draw. Declaration of financial interests. While the President acknowledged that he still retains certain interests in Phala Phala farm as a game and cattle farm operation, he submitted that he does not conduct any other paid work or in relation to the farm as envisaged in Section 96, subsection 2A of the Constitution. On the 7th of October 2022, the PPSA investigation team inspected the Register of Financial Interest of the President, in particular for the period between 1st of April 2019 to the 21st of March 2020. The President's financial interest and members' interests held in Dabanyoni and Chibasa Trust were declared. The value and the nature thereof were also disclosed in the financial register kept in the office of the Secretary to Cabinet. On the remuneration part of the register of the financial interest of the President, it was observed that the President declared that he received no remuneration other than as a member of the executive during the reporting period 2020 as required in terms of paragraph 5.6 of the Executive Ethics Code. The President indicated further that he instructed Mr. Stainspeed of his office to ensure compliance with the Executive Ethics Code as required by paragraph 8.1 and that he is aware of the provisions of the Executive Ethics Code regarding the proper conduct expected of the members of the Executive. The President's interests in Dabanyoni and Chibase Trust are described as, I quote, registrable interest, I unquote, and records inspected indicated that he has declared this investment as financial interests which he has in corporate entities. In terms of paragraph 6 of the Code of Ethics, financial interests refer to registrable interests that must be disclosed, such as shares of other financial interest in companies and other corporate entities, sponsorships, gifts and hospitalities other than that received from a spouse or permanent companion or family member, benefits, foreign travel other than personal visits paid for by the member or official travel paid for by the state, travel paid for by the member's party, land and immovable property, including land or property outside South Africa, and pensions. No evidence could be found indicating that the President either works at Phala Phala Farm or receives remuneration from Phala Phala Farm. The Executive Ethics Code creates a distinction between the concept of paid work or remuneration, as contemplated in paragraph 2.3g of the Code of Ethics, and financial interests as described in paragraph 6 of the Code of Ethics. The objectives of this distinction in the Code of Ethics is to separate the paid work, undue influence on political behavior, and conflict between the constitutional duties. Evidence arising from the inspection of the President's Register for Financial Interest reveals that the President retains financial interest in Dabanyoni, as described in paragraph 6 of the Code of Ethics. While not conclusive, these facts certainly point towards the President being more actively involved in the management of the affairs of the close corporation than he appears to let on in his general submissions. There are, of course, other facts which point away from the President being involved in paid work. For one thing, he neither draws a salary from the Dabanyoni CC, nor receives any distributions, only the payment of a soft loan. He evidently is not often physically present at the farm. Looking into the risk of a conflict of interest, paragraph 2.3f of the Executive Ethics Code and section 96, subsection 2b of the Constitution stipulate that members of the executive may not expose themselves to any situation involving the risk of a conflict between their official responsibilities and their private interests. The aim of these provisions is to prohibit conduct that is inconsistent with a member's office or that which exposes a member to any situation involving the risk of a conflict between his or her official responsibilities and private interests. A conflict of interest is a situation in which a person has a duty to more than one person or organizations, but cannot do justice to the actual or potential adverse interests of both parties. According to the King 4 report on corporate governance in South Africa of 2016, a conflict of interest used in relation to members of the governing body and its committees occur when there is a direct and indirect conflict, in fact or in appearance, between the interest of such member and that of the organization. It applies to financial, economic, or other interests in any opportunity from which the organization may benefit, as well as use of the property of the organization, including information. The Organization for Economic Cooperation and Development, known as the OECD, is a unique forum where governments of various democracies work together to address the economic, social, and environmental challenges of globalization. South Africa is a key member state to the OECD, having joined on the 16th of May 2007. The OECD is also at the forefront of the efforts to understand and help governments respond to new developments and concerns, such as corporate governance, managing conflict of interests, and to seek answers to common problems, identifying good practice, and work to coordinate domestic and international policies. In its report or toolkit titled, I quote, Managing Conflict of Interest in the Public Sector, I unquote, emphasis is placed on the pressing need to properly manage perceived or potential conflict of interest and provides inter alia, I quote, a conflict of interest is not necessarily corruption, which is understood as actual abuse of public office for private advantage, but a conflict does have the potential for corruption conduct. Conflicts between private interests and public duties of public officials must therefore be correctly identified, appropriately managed, and effectively resolved. Left unresolved, a conflict of interest can result in corrupt conduct, abuse of public office, misconduct, breach of trust, or unlawful action. More important, public confidence in the integrity of the public institutions can also be seriously damaged, I unquote. A conflict of interest is not in itself misconduct. However, failing to recognize it or manage it appropriately is at best improper. The private interest of an official assumes a public dimension only if and when it impinges on or is perceived to impinge on some action or decision the official must take in the course of duty. If this occurs, the official becomes conflicted and must promptly consider the proper ethical path to take in the particular case. In the Western Cape High Court, the court held the test regarding a conflict of interest, I quote, rests upon the broad doctrine that a man who stands in a position of trust towards another cannot in matters affected by that position advance his own interest by making a profit at that other's expense, I unquote. There are many different views on the definition of a conflict of interest. However, the common scheme presents in all definitions relates to a clash between the official and business duties of the decision maker concerned and his or her personal interests. The official or business interests are often described as the primary interests, while the personal interests are regarded as secondary interests. Primary interests refer to the principal goals of the profession or activity and duties of the public office. Secondary interests include not only financial gain, but also such motives as the desire for professional advancement and the wish to do favors for family and friends. But conflict of interest rules usually focus on financial relationships because they are relatively more objective, fungible, and quantifiable. Again, paragraph 3 of the code makes it clear that not all interests held by a member of the executive will give rise to a conflict for purpose of the code. The existence of a secondary interest is therefore not treated as wrong in itself, but becomes objectionable when believed to have greater weight than the primary interests. The conflict in a conflict of interest exists whether or not a particular individual is actually influenced by the secondary interests. It exists if the circumstances are reasonably believed on the basis of past experience and objective evidence to create a risk that decisions may be unduly influenced by secondary interests. Again, as this provision makes clear, Not all interests held by a member of the executive will give rise to a conflict for purposes of the code. This is clear when regard is had to paragraph 3.6, which requires a member to disclose of an interest in a company or corporate entity or profit-making enterprise, or place it in the management of an independent person if that interest may give rise to a conflict of interest in the performance of that member's function as a member of the executive. The President contended that he had been advised that the kind of interest he retains in Phala Phala Farm as a game farm and cattle farming operation does not give rise to a conflict of interest or expose him to any situation involving the risk of a conflict between his official responsibilities and his private interests. He retains assets which he believed would not give rise to a conflict of interest, including his members' interest in the CC that operates Phala Phala. He also remains both a trustee and beneficiary of the Chibase Trust, which owns the farm property. In the abstract, ownership of a farm or corporate entity that runs a business on a farm is very unlikely to give rise to a conflict of interest in the performance of a member's functions as a member of the executive. In terms of the evidence placed before the public protector, the day-to-day operations of Phala Phala Wildlife are managed by Mr. von Wellach as the general manager with the assistance of about 40 employees. Though occasionally when the President visits the farm, they would seek evidence from him, advice from him, and he would give guidance. The buffalo sales transaction between Mr. Ndlovu and Mr. Hazim took place in the absence of the President, thus indicating that he is not involved in the ordinary business decision-making largely. The evidence revealed that the President held discussions with farm managers, notably regarding the disposal of certain animals due to them being substandard. Considering the evidence in its entirety and the application of the law, there is no basis to exalt such deliberations to a degree where it can be held that there existed a real or potential conflict of interest on the part of the President regarding his duty as the head of cabinet and his interest in the game cattle farming at Phala Phala Farm in violation of the code. Thus, no evidence could be found to underpin a finding or a conclusion that the President's comments or utterances in the regard were a continuous act to be considered or construed as active involvement in the business or paid work. Aggregated against the standard imposed by the Executive Ethics Code, it is found that there is no basis upon which to conclude that the President contravened Clause 2.1b, D, Clause 2.3d, F and G of the Executive Ethics Code, including the period following the alleged theft of the US dollars that took place on or about 9 February 2020 from his private house at Phala Phala Farm in Waterberg, Limpopo. Therefore, the evidence does not support the allegation that the President's financial interest in game or cattle farming at Phala Phala Farm exposes him to any situation involving the risk of a conflict between his official responsibilities and his private interests. Accordingly, the allegation that the President improperly and in violation of the provisions of the Executive Code exposed him to any risk of a conflict between his constitutional duties and obligations and his private interest arising from or affected by his alleged paid work at Phala Phala Farm is not substantiated. Moving over to the second issue, evidence indicates that Phala Phala Farm was not listed as the President's private residence on which there was a full-time deployment of the PPS personnel at the time of the crime of the housebreaking with the intent to steal and theft, because the President chose not to have it listed as he seldom visits the farm. This, according to the President, was intended to mitigate the use of state resources. According to General Rueda, since his appointment on the 1st of June 2018, he attempted to persuade the President that PPS personnel should be deployed at the farm, as the President visits as one of his private residences. General Rueda stated that when the President was not at the farm, there were no subs or PPS members to prevent breaches of security. General Rueda further indicated that the President has always refused the deployment of PPS personnel and technology at the farm. Having regard to the applicable prescripts, notwithstanding the President's initial refusal to have PPS deployed at Phala Phala Farm, paragraph 12 of the Presidential Handbook, read together with the PPS policy, prescribes that the SAPS must take full responsibility for the protection and security of the President at all times during his term of office. These prescripts stipulate further that protection and security measures of the President include, inter alia, regular security assessment in conjunction with intelligence agencies and static protection at all official and private residences, and office accommodation used from time to time during his term of office. According to evidence of General Rueda, Mr. Ndlovu, and Mr. von Wellach, and the President on the 10th of February 2020, there was a security breach by intruders at Phala Phala Farm, which the President reported to General Rueda on the same day. Thereafter, Mr. Ndlovu reported to the President that the money from the sale of game was stolen from the President's residence at Phala Phala Farm. After confirming same on the 2nd of March 2020, the President reported that the theft of money from the sale of game to General Rueda. Having considered the response of Mr. Zungula, the contention that the President was the only person as a member of the close corporation to report a crime as directed by Section 34(1) of PRECA is not supported by a proper reading of the relevant section, and that both Mrs. von Wellach and Mr. Ndlovu too were persons of authority mandated to report the theft as envisaged in Sections 34(4)(e) and Roman figure 1 of PRECA, and had an obligation as persons with the personal knowledge of the crime to report the housebreaking. Section 34 subsection 1e and numeric 1 of PRECA places the duty on certain persons to report certain offenses. Failure to report is an offense. In this case, the public protector is not empowered to pronounce on the merits and demerits of the alleged crime and to make findings in respect thereof, because the offense does not fall within Section 6 subsection 4a of the Public Protector Act. The matter is being investigated by the public body which is tasked with criminal investigations, namely the DPCI. In a letter dated 26 April 2023, General Masemula confirmed to the investigation team that on the 22nd of August 2022, Mr. von Wellach opened a case, namely Bila Case 29908 of 2022, for housebreaking and theft that took place on the 9th of February 2020. In considering Mr. Steenhuisen's submission for the public protector to reject the notion and evidence that the President did not instruct, consent to, or otherwise know of the unlawful investigations by members of the SAPS, the public protector heeded the advice of the Constitutional Court that where evidence is inconclusive or incongruent, she is obliged, the institution is obliged to carefully evaluate it to determine the truth. This decision affirms the objective of investigations by the public protector is to discover the truth. Where the investigation yields disparate pieces of evidence which do not fit into place, the public protector must continue digging until the true picture emerges. The court further noted that when the versions placed before the public protector divergent on same of the issues, she should not, without more evidence, prefer one version over the other. I quote, "The truth is established by facts and not by one's preference," I unquote. The Constitutional Court furthermore warned that the public protector has no place summarily dismissing any information. His or her function is to weigh the importance or otherwise of the information, and if appropriate, to take steps that are necessary to determine the truth. To this end, and having identified witnesses who were interviewed and approached for information and their testimony, this report sets out in detailed form the evidence of each witness. These include the president, the managers of Phala Phala Farm, as well as the members of the SAPs involved. The evidence was obtained by means of a proactive and systemic investigative process and was thoroughly scrutinized. The substantive evidence and information at the disposal of the public protector is corroborative of each other on all relevant issues and cannot, on a balance of probabilities, be construed or perceived as inconclusive or congruent or summarily dismissed. Determination of the origin and exact amount of the money stolen from Phala Phala Farm was not within the scope of the investigation of the public protector. It is therefore incorrect to summarize that the public protector seems to be satisfied with the quantity or origin of the foreign currency stolen. The focus of the investigation was only on the three distinct identified issues in the report. The concept of abuse of power is not defined in the Public Protector Act. However, in terms of the dictionary meaning, it is defined as wrongful use of a position of authority to influence employees, students, colleagues, or volunteers, coercion to participate in activities or decision-making in violation of laws, regulations, or policies. In the matter of Gigaba versus the Minister of Police and others, Saduala J. gave an example of abuse of power as an instance in which powers given to the public authorities to be used for certain purposes are wrongly used by them to achieve another unauthorized ulterior purpose. In this case, the court held that the involvement of the Hawks or the DPCI in the trivial domestic spat amounted to the abuse of power by Mr. Gigaba as the former minister in using the state administration for his own personal benefit for the intention to intimidate the applicant. In determining this issue, evidence was evaluated to establish if the conduct of the president can be equated to an abuse of his position of power and whether he utilized state resources, which included deployment of PPS members to Phala Phala Farm and to investigate the crime of housebreaking with the intent to steal and theft without a registered case to recover the stolen money. In response to the notice, Mr. Steenhuisen stated that the president consented to or knew of the use of PPS resources beyond its mandate. Mr. Steenhuisen insisted that the president acquiesced either or actively or passively in the abuse of power and PPS resources. Mr. Steenhuisen did not furnish any evidence to support this contention. No evidence could be found to prove that the president was aware of the investigation of the crime by General Roeder. As a result, a finding cannot be made that assumes a position with respect to the president's state of mind without empirical evidence to support the allegation that he consented to the use of PPS resources beyond their mandate or for an ulterior purpose. Regarding the third issue, on the 20th of October 2022, Sergeant Rikhoto stated on record during the interview with the investigation team that while he and General Roeder interviewed Mr. David Joseph at Phala Phala Farm, Mr. Joseph admitted that he arranged with his Namibian friends from Cape Town, who subsequently broke into the president's private residence at Phala Phala Farm and stole cash in US dollars. According to Sergeant Rikhoto, Mr. Joseph was given a share of 30,000 rand and he was angry that he was not given enough money for his role. The interviews conducted with suspects at Phala Phala Farm in March 2020 were also confirmed to the investigation team by General Roeder himself on record. It was further revealed by General Roeder in paragraphs 2 and 4 of his supplementary affidavit dated the 1st of September 2022 that when he interviewed Mr. Joseph in March 2020, he read his constitutional rights to him. These rights are understood to be read to a person who is being arrested, detained or accused in terms of Section 35 of the Constitution. The act of reading these rights to Mr. Joseph is indicative of an interaction between a police officer conducting a criminal investigation and a suspect. The information disclosed to both Sergeant Rikotso and General Rueda by Mr. Joseph during the interview held on the 3rd and the 4th of March 2020 places a legal duty on them as police officers in terms of Section 13, Subsection 2, Subsection 3 of the SAPS Act to report to the commanding officer or to perform such duty in a manner that is reasonable under the circumstances. It is tried and a settled fact that housebreaking with the intent to steal and theft is a common law offense in South Africa. The Supreme Court of Appeal in the matter between the state versus Bakane and others in paragraph 30 held that a rigid interpretation of Section 13, Subsection 2 of the SAPS Act that may amount to an interpretation that a member of the SAPS has no legal reporting duty to report other crimes that are not created in regulations, such as the shooting incident in question. It is a brazen perversion of the section which cannot be countenanced, least from law enforcement officers. I unquote. The court stated that this duty flows from Section 205, Subsection 3 of the Constitution and is affirmed by the SAPS Act. Therefore, General Rueda and Sergeant Rikotso were legally obliged to act in line with the provisions of Section 13, Subsection 2 and Subsection 3 of the SAPS Act upon becoming aware of a crime, namely a common law offense of housebreaking with the intent to steal and theft, that it had been committed, and more so when suspects made admissions to them during an interview in respect of the same crime or offense. According to the evidence, General Rueda reported this incident to General Mfazi, who was neither his commanding officer nor part of the DPCI as contemplated in Section 34 of PRECA. General Rueda indicated during his interview that the investigating team, that he opted to report this matter to General Mfazi, who is since late as the head of crime detection services, and also because the National Commissioner was busy with performance assessments. General Rueda further stated that another reason for reporting to General Mfazi was that their officers were in the same corridor. However, in terms of the SAPS approved national and provincial organizational structure for 2020-2021 financial year, General Rueda, as the component head of the PPS, reports directly to the National Commissioner of the SAPS. Evidence further indicates that General Rueda conducted an investigation assisted by Sergeant Rikotso, Mr. Trevor Fredericks, and Nick to investigate this incident without a case having been registered on SAPS CAS. It is important to note that although Mr. Fredericks and Nick assisted General Rueda to conduct his investigations, they were not members of the SAPS. The evidence and objectively ascertainable facts around the activities of General Rueda, Sergeant Rikotso, and Nick do not support the assertion that these were primarily aimed at conducting a threat analysis or assessment in respect of the President or his private residence at Phala Phala Farm in accordance with the applicable legislative framework. It is noted from the following statement by General Rueda, which confirms the investigation of crime, the tracing and following of money stolen from Phala Phala Farm is contained in his supplementary affidavit. I quote, "When I was in Cape Town around the 10th or 11th of March 2020, I received a call from Sergeant Rikotso, who told me that he had found out from certain sources that the perpetrators of theft had bought new cars. He said that the cars had been bought from Barons in Cullenberg, Cape Town. Shortly after receiving the call, from Sergeant Rikotso, he picked me up at my office in Gama House opposite Parliament. We drove to Barron's Motors and spoke to the manager, who confirmed that on the 14th of February 2020, a Mr. Mukekeni had purchased a 2019 Ford Ranger and supplied further details in relation to the purchase of the vehicle." I unquote. The above extract from General Rueda's supplementary affidavit is corroborated by the affidavit of Mr. Mali, who was the car sales manager at Barron's in Cullenberg, Cape Town, which indicates that the police officer requested details of the sale transaction, identified and residential address of the buyer. Furthermore, the report compiled by Sergeant Rukoto only addresses issues related to the crime of the housebreaking with the intent to steal and theft at Phala Phala farm. The report by Sergeant Rukoto is clearly tabulated into 3 distinct headings which focus on crime as follows: A. Role players in the planning and commission of crime. B. Background of what transpired until the commission of crime. And C. Surveillance and gathering of information of individuals connected therewith. It is noted that the report by Sergeant Rukoto specifies each subject, the role played by each during the commission of the crime, and what was bought with the money they stole from Phala Phala farm. This report by Sergeant Rukoto does not make any remarks, conclusions, and findings about any threat or risk assessment to the personal safety of the President or his family. While Sergeant Rukoto, in his response to the notice, contains that he was merely acting on the instruction of his supervisors or superiors, it is a tried principle of law that employees are not under any obligation to obey unlawful or illegal instructions. Employers, including SAPS, have developed job descriptions in order to assign certain tasks to certain units or employees in order to promote efficiency and accountability. In the circumstances, a job description should have guided Sergeant Rukoto's refusal to perform the certain duties or tasks if he believed it fell outside the scope of his job description. In the matter of the City of Cape Town versus Nkomo and others, the Labour Code confirmed that the employees are not obliged to obey to unlawful instructions. In light of the above, the refusal to obey to an instructions to do work that was unlawful or that Sergeant Rukoto legitimately felt he was not qualified to perform could not have been held to constitute insubordination. The fact that Sergeant Rukoto acted on his superior's instructions, who is General Rueda, could not by itself have justified his conduct to obey unlawful instructions. An employee is under no obligation to obey an unlawful instruction. If he obeys an unlawful instruction, he does so at his own risk. Further observations are made. It is noted that Mr. Chauke, who is neither in the employ of the SAPS nor covered by the REMIS policy, traveled to Namibia on the 25th and 26th June 2020, accompanied by General Rueda using PPS resources with the approval of General Sithole. The request for the trip approval was signed and submitted by General Rueda on the 24th of June 2020, and it is clear from paragraph 1 of the memorandum seeking approval of the trip that General Rueda would be accompanying Mr. Chauke to Namibia from the 25th of June 2020 to the 26th of June 2020. However, in terms of the evidence, no link or nexus could be established between the trip to Namibia and the investigation that was conducted by the PPS in respect of the crime of housebreaking with the intent to steal and theft committed at the Phala Phala farm on the 9th of February 2020. The Public Protector is empowered in terms of Section 182(1)(c) of the Constitution to take appropriate remedial action with the view of redressing the conduct highlighted in this report where adverse findings are made. With due regard to the evidence, the regulatory framework determining the standard that members of the PPS, namely General Rueda and Sergeant Rukoto, should have complied with, hereby the following remedial action in terms of Section 182(1)(c) of the Constitution is taken. The Minister of the South African Police Service must take note of the findings of maladministration and improper conduct against the SAPS as highlighted in this report in connection with the allegation that the members of the SAPS attached to the PPS acted improperly by investigating the crime of housebreaking with the intent to steal and theft, which took place on or about the 9th of February 2020 at Phala Phala farm, in line with the authority vested on the Minister of Police in terms of Section 206 of the Constitution. The National Commissioner of SAPS must, within 60 calendar days from the date of receipt of this report, ensure that appropriate action is initiated against General Rueda and Sergeant Rukoto for contraventions of the SAPS prescripts as highlighted in this report, in line with the provisions of Section 40 of the SAPS Act and Regulation 6 of the SAPS Discipline Regulations 2016. must within 90 calendar days from the date of receipt of this report develop an appropriate PPS directive, instruction, policy or such other prescripts within the statutory powers vested in the National Commissioner in terms of Section 11 of the SAPS Act and Section 207 subsection 2 of the Constitution, directing how the PPS members must manage crimes reported directly to them by the VIPs under their protection. For monitoring by the Public Protector, the SAPs are to provide a report to the Public Protector on the implementation of the remedial action within 60 calendar days from the date of this report. The importance of the implementation of the Public Protector's remedial action is no better evidence than through the amazing work of the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, which is a product of the remedial action of the Public Protector South Africa. Given the magnitude of the commitment and efforts that have gone into the work of the Zondo Commission, the Commission's findings would be the logical starting point for any retrospective understanding of the existence, nature, and extent of the state capture or prospective remedial measures to prevent a recurrence. The Commission's findings on the mechanisms and causes of state capture, and in particular institutional weaknesses in the state, provide a strong foundation for implementing crucial reforms. Ethical leadership in the public sector, including the government agencies and SOEs affected or involved in state capture, is a critical foundation to curb corruption and ensure good governance. Leadership should be participatory, consensus-orientated, accountable, transparent, responsive, effective and efficient, equitable and inclusive, and follow the rule of law. This could ensure that corruption is minimized, the views of communities are taken into account, and the voices of the most vulnerable in society are heard in decision-making. For the Public Protector, this journey is, however, far from over. As stated in the report, we will continue to monitor the remedial action. At this juncture, I take this opportunity to confirm that we have received Parliament's progress report as at 26 June 2023 on their implementation plan of the remedial action stemming from the state of capture report as well as the progress. These reports are expected to provide progress on the President's broad commitment to reforms in the areas of whistleblower protection and incentivization, procurement reform, and capacitation and strengthening of laws and law enforcement and other accountability institutions such as ours, the professionalization of the public administration, and the protection of public institutions from abuse. We confirm that Parliament has advised inter alia that the National Assembly has requested the Minister of Justice and Correctional Services to investigate possible shortcomings in the legal framework regulating the ethical conduct of applicable to executive members, including specific aspects of the remedial action in paragraphs 8.9 of the State of Capture report as it relates to the Executive Members Ethics Act 1998 that may require legislative amendments, and to introduce these to Parliament as a matter of urgency. As for the transversal code of conduct of all members of the state, the Department of Public Service and Administration indicates that the code was actually revised extensively in 2016. Currently, the public service regulations of 2016 of the Public Service Act 1994 are being updated to bring them in line with the Public Administration Management Act of 2014. Coupled with the amendments to the Public Protector Act that we have submitted to the Minister of Justice and Correctional Services on the 5th of June this year, we are confident that the work of the Public Protector will soon, more than ever before, produce its intended purpose of truly being a vanguard of the South Africa's constitutional democracy. Once again, on behalf of the Public Protector team, I express my sincerest gratitude to the members of the media for making it possible for us to share our work with the nation, the continent, and indeed the world. We also extend our thanks to the various departments that have cooperated with the Public Protector during our investigations. We are thankful to the people of South Africa for your patience in allowing us to complete our work, particularly in the Phala Phala report, and to all those watching and listening through this media streaming, for taking the time to witness our work. But also let me take the time to acknowledge the investigators who did the Phala Phala report. Mr. Khulile Mtiki, Mr. Vusumuzi Dlamini, led by the Acting Chief Operations Officer, Advocate Nelisiwe Nkabinde, and also the work done by the Chief Executive Officer to quality assure the report and assist me in its completion. The courage that you have shown throughout this work, the resistance that you have shown throughout this work, it is indeed what was envisaged by the Constitution, that the public protector shall perform its duties and carry out its mandate impartially, independently, without any fear, favor, or prejudice. I also wish to thank all the executives for the role that they have played in the quality assurance of this matter. I would like to thank the team across the country for the valiant efforts that they have put into holding the name of the public protector up high and continue to work, and for this quarter for having produced the reports that they have produced in service of the people of South Africa. I thank you.
Thank you.